Hi everyone. Today's video is about the challenges around flexible working and returning to the workplace, particularly how SMBs can deal with a flurry of flexible working requests efficiently and avoid expensive and time-consuming litigation, particularly around workplace discrimination. My name's Adam Morgan. I've been a barrister for over 25 years and I specialise in providing legal advice and services to SMEs across a wide range of commercial sectors. I'm also one of the founders here at Grow5. Now, as businesses navigate the easing of lockdown restrictions, employers are turning their minds on how to manage their employees returning to the workplace. Considerations include what changes employers are legally obliged to make, and also what requests for changes to working conditions for employees can be refused or renegotiated. Today's video is designed to provide an overview of a number of the key questions that employers will have to consider, together with a synopsis of the relevant employment law principles. Now, before I dive into those questions, one of the principal considerations that I feel employers should always bear in mind when approaching this topic is that an overly legalistic approach can easily have a negative impact on staff and staff morale. As most employers know, creating a good workplace culture and a sense of tribe amongst your employees is often difficult and time-consuming to build. Equally, it's also something that can be very quickly lost, so it pays to tread carefully and to ensure that there's adequate consultation with staff so that they don't feel as though they're being ridden roughshod over during the process. Now, I'm going to preface that last statement by saying that of course I appreciate the commercial reality of running a business, and I'm not suggesting that this topic is approached solely from an employee perspective. A number of employers have provided feedback to us along the lines of the fact that performance has been an issue with a large number of staff working independently at home. There's also an acceptance that continuing with a blanket policy of staff working at home would inevitably have a long-term negative effect on businesses. Consequently, there are often good commercial reasons to justify a return of staff to the workplace, be it either on a full-time or flexible basis, and I'll come on to look at that in a bit more detail in a moment. So with that in mind, let's dive straight in with some of the most pressing questions around this topic. And the first question that we're normally asked is, do employees have a general right to work from home or adopt flexible working as we emerge from lockdown? Well, the new normal has created a new approach to work, and the flexibility that working from home provides is attractive to many employees. Now, some roles are conducive to working from home, but not all roles are, and not all employees are the same. And as I've already said, a number of employers recognise that greater efficiency can often be achieved by having employees back together in the office. Now, from an employment law perspective, there's no automatic right to work from home. Most employment contracts will specify the normal place of work for that employee. However, if a particular employment contract does permit working from home or flexible working, then the employer will be bound by those terms. And what that also means is that the normal rules around renegotiating any contractual term will apply. Now, changes can of course be made to an employment contract, but that requires the consent of the employee. So if an employee has been allowed to work from home, or there's been any other change to that contractual requirement, then that change can become a new term of the employment contract under the principle that a variation can take place by custom or conduct between the parties. So what that means is that if there's a proper evidential basis to suggest that a variation by conduct has taken place, then it can be difficult to change the employment contract back to what it was before. Now, every situation will of course need to be judged on its own facts, and the approach taken by individual employers will be important. I say that because with the effect of the earlier lockdowns beginning to bite, a number of employers specifically stated to their employees that the requirement to work from home was in accordance with government guidance, it was temporary, and furthermore, they specifically reserved the right to make subsequent changes to that policy in order to meet the future needs of the business. Now, if you're one of the employers who adopted that approach, then great, because on the face of it, you will probably be able to revert back to the original contractual terms. However, if you didn't follow this process, then as a business, you'll be obliged to adopt a more cautious approach when seeking to make amendments to the current working arrangement. Now, the second most common question we are asked is, do employees have any statutory rights to work from home or adopt flexible working? Well, in short, no. If an employee wishes to continue to work remotely and there has been no variation to their contract allowing them to do so, they will have to make a formal request in writing to their employer. So in order to be eligible to make a request to work flexibly, an employee must have worked for the same employer for 26 weeks. However, it's really important to bear in mind that equality law rights are not subject to time limits, and they accrue from the first day of employment. And that's something I'll come on to look at in a bit more detail in a moment. So how then do employers deal with requests for flexible working? Well, if an employer receives a formal request to work flexibly, which includes a request to work from home, they are of course obliged to consider the request. Now, this isn't something that's new. That's been the position for a number of years, and it's not something that's altered simply because of the impact of COVID. Employers should, of course, expect that the number of requests for flexible working will increase because of the impact of COVID and the changes that's necessitated in the workplace. So it would therefore be prudent for employees to anticipate such an increase, and also to allocate sufficient resources to ensure that any requests are properly considered and any decisions are objectively justified. And we'll come on to look at that in a bit more detail in a moment. So that brings me nicely on to the next question, which is, what constitutes a fair process when considering a request for flexible working? So when considering a flexible working request, an employer must carry out an objective assessment of the employee's request for flexible working. And this will include assessing the advantages and disadvantages of the request. They must also hold a meeting with the employee to discuss the request and understand any particular reasons associated with the request. And an employer must also make a decision within 3 months. That can be longer if agreed with the employee. And with all these decisions, it's advisable that any decision is objectively justified. And also, finally, the employer must provide an appropriate appeal process in the event the employee's request is refused. Now, what's particularly important is that employers need to be alert to the dangers of discriminating both directly and indirectly against working parents, the majority of whom tend to be women, also carers of disabled persons, or against adults who are themselves disabled, all of whom have protected characteristics under equality law. Now, this is particularly important because in the event that an employee brings a successful discrimination claim, there is no cap on the compensation that an employment tribunal can award. And from memory, the average award in a successful discrimination claim in 2019 and 2020 was somewhere in the region of £14,000. So finally, on this point, if a flexible working request is approved, the employer must change the employee's terms and conditions and confirm a start date for flexible working no later than 28 days after approving the request. So the next question I'd like to consider is, are employers obliged to grant a request for flexible working? Well, employers can refuse a request for flexible working, but any refusal must be supported by a good business reason for doing so. Now, there's no definitive list as to what constitutes a good business reason, but examples could include the additional costs that can be involved and the damage to the business as a result of the proposed change. It can also include the fact that flexible working will have a negative impact upon the performance of the role in question, and also that the proposed flexible work schedule will result in the business not being able to meet legitimate business demands. Now, as I've already mentioned, where an employer refuses a request for flexible working, they must notify the employee in writing, setting out the appropriate business reasons for that refusal. The employer, as I've already said, should also give the employee the right to appeal against that decision. Now, any appeal process should be in accordance with the employer's appeal procedure, and indeed any other relevant processes contained within the staff handbook or any other relevant documentation. Now, care should also be taken to ensure that any employees who have been refused to work flexibly, they should not be treated less favourably as a result of their request, as that can also result in a claim for discrimination or indeed unfair dismissal. So what are the considerations around a phased return to work? Well, in our opinion, it's unlikely that all staff will return to the workplace at the same time. Therefore, a phased return will be more probable. However, employers need to take care when devising a policy for a phased return to ensure that it's fair to all staff and that there's adequate communication and consultation with those staff members who are affected. It's also important to bear in mind that considerations of fairness apply to both the substance and implementation of any process. There will almost inevitably be challenges and complaints from staff who are asked to go back to the workplace, particularly when other members of staff continue to work from home. Therefore, it's really important to consider whether any phased return to work policy indirectly discriminates against any particular groups of individuals. As I've already said, women or employees with disabilities are groups that employers really have to pay close attention to. And any deficiencies in the drafting or implementation of the policy may prove costly in terms of discrimination, which in any business can also result in the loss of key members of staff. So what are the conclusions and suggestions for employers? So really wrapping this up, many employees have become comfortable working remotely since lockdown restrictions were imposed back in March 2020. Once these restrictions are eased, many employers will inevitably want their employees to return to the workplace, either on a full-time or part-time basis. And such a change may well result in reluctance and even pushback from a significant number of staff. Some employees may want to continue working remotely, others may decide that they don't want to go back to their previous working patterns. So employers need to be prepared so that their actions in dealing with this transition out of lockdown does not end up with employees bringing numerous claims, including claims for discrimination against them. Dealing with a large number of claims is costly, it's time consuming, and it can detract focus from the actual running of the business, which is obviously the most important thing. So the easing of lockdown restrictions will inevitably present a number of challenges for employers. And when navigating these challenges, it will be good practice to have, for employers rather, to have the following in place, or at least in mind. Firstly, we would suggest a well-articulated and well-communicated plan for emerging from lockdown. That should include identifying which employees are required back and the reasons that underpin that policy because of their particular roles. Secondly, a coherent overview of the needs of the business. In the event that a dispute does arise with staff around a return, employers need to be able to articulate good business reasons to insist that those employees return to the workplace. Also making suitable adjustments to the workplace, thereby ensuring a safe working environment for those staff, and also to fulfil any health and safety obligations the employers have. Similarly, appropriate resources are in place to deal with the requests for remote working and indeed any subsequent appeals associated with that. Employers should also consider the impact the pandemic has had upon their staff and be sympathetic about any apprehension to returning to the workplace, and that's associated with travel and being around other people. Employees that feel they're being considered and their concerns heard are much more likely to work in harmony to achieve change rather than offer resistance to it. So I hope that was an informative short Q&A for you. If you have any queries, please feel free to contact us. We're happy to help. You can also subscribe to our channel by clicking at the top here. We will be hopefully producing quite a lot of content around the challenges of growth in the next month or so. So please let us know in the comments section if there are any particular topics you'd like us to deal with so we can make our content as useful as possible.